explore whether it is possible to make the best use of the available resources, I mean to say manpower, to deliver justice quickly. In this chapter, I wish to speak about the procedure to be adopted by judges, especially in the subordinate judiciary, to pronounce judgments quickly with minimum of strain for themselves. Let me now go straight into the subject. Order 20 CPC enjoins that the court shall pronounce judgment at once after hearing the arguments. How is it possible for a judgment to be pronounced at once? Were the lawmakers who made this provision ignorant of the role of the judge? Is it not the duty of the judge to go through the entire record, each and every word in the judgments that are cited by the advocates, as the advocates have a tendency to highlight only a portion of the citation that is favorable to them and hide the unfavorable portion? Is it not the duty of the judge to act like a source of justice? Just as the rivers have their own sources and fountains have their source in fountain heads, the answer is that most modern judicial systems are designed on the adversarial pattern. In this pattern, the judge acts like a neutral referee in a match. A division bench of the Honorable High Court of Andhra Pradesh correctly described the role of a judge in our adversarial system in the following words, open quote, I can blow my judicial whistle when the ball goes out of play, but when the game restarts, I must neither take part in it nor tell the players how to play, unquote. This is a division bench ruling reported in 1992-3 Andhra Law Times 551. The task of an inquisitorial judge in a commission of inquiry is to investigate and discover the truth, whereas the task of a judge in the adversarial process is to merely cross-check whether the hypothesis of the plaintiff or the complainant is tenable in the eyes of law. As Justice Sri Krishna said, a judge should stay aloof like a referee and not snatch the bat and hit a six. Every judge is like an impartial referee or umpire in a match. Just because a judge has a passion for basketball, he cannot apply the rules of basketball while judging the play in a football match, as this would result in the winners being declared as the losers and losers as the winners. The players would have played the match keeping the rules of football in mind, as per which touching the ball with hands results in penalty points, while in basketball it is the exact opposite. Now let me explain the design of the Indian judiciary. Our judicial system is designed on the adversarial pattern, which is also considered to be the most impartial system. The following provisions show that the system is not inquisitorial but adversarial. 1. Section 101 and 102 of the Evidence Act clearly place the onus of proof on the parties who make their respective allegations. If judges were to act like investigators, the Act would have placed the burden of discovery of truth on the judge. In the Commissions of Inquiry Act, there is no such restriction on the role of the judge because it is for the judge to find out the truth by his active involvement. He cannot stay aloof as an umpire, but at the same time, at the end, he cannot pronounce judgment but only submit a report. Even a judge of the Supreme Court or High Court, when heading a commission of inquiry, cannot pronounce judgment convicting or acquitting anyone. For instance, when there is a plane crash resulting in loss of hundreds of lives, both in the plane and on the land where the plane crash landed, a Supreme Court judge who is appointed as the head of the Commission of Inquiry is expected to act like an investigator and not remain as a neutral referee in a match. The pilots of the plane may accuse the ground crew of negligence, and the latter might blame the pilots. There would also be other theories that on account of mechanical breakdown or sudden gust of crosswind or sabotage by some terrorists, the crash would have occurred. The judge has to investigate into the various versions and come to his own conclusion, just as a police officer does the investigation. Based on the report of the inquiry, the government may or may not act upon it, as it is not binding. If it decides to act, prosecution is launched against the persons who are reportedly guilty of negligence as per the report of the Supreme Court judge. Only the magistrates court or the sessions judges court, where these functionaries become only referees and not fresh investigators, over and above the investigation report of the Supreme Court judge, can ultimately pronounce judgment either convicting or acquitting the accused. In fact, in all advanced countries, it is the juries that will decide the guilt or innocence of the accused and not the judge alone. The judge only decides questions of law, while the questions of fact are decided by several jurors. Because while deciding facts, the experience of the judge, the mental makeup of the judge, they also count. It will be wrong to put all our eggs in one basket. Similarly, if you entrust all powers only to the judge to decide both the questions of law and questions of fact, it would result in a sort of a tyranny of the judge. That's why the legal profession in India became rather mellowed and lost its ability to fight corruption or whatever it is in the judiciary once the jury system was abolished way back in the 1960s. Next point, now I am only trying to list out why and how I say our system is adversarial and not inquisitorial. The next point is Section 138 of the Evidence Act does not prescribe that the judge should put questions to witnesses. Then, next point is Section 165 of the Evidence Act no doubt empowers the judge to put questions, but various authoritative pronouncements say that the judge must not put questions in an inquisitorial manner. For instance, 1969 MLJ, criminal, page 499. Judge must not descend into the arena. AR 1954, Calcutta 305. Then Laws, Gujarat 1993-4-40. Hasmukh Bhai Chinnu Bhai Shah versus State. In this decision, it was held that in order to maintain its aloofness, even the Lokayukta, which does not conduct adversarial proceedings but is an investigator, also may appoint a counsel for Lokayukta to cross-examine the witnesses in the course of the inquiry instead of doing it itself. Next point, Section 151 CPC, though gives wide discretion, open court, it cannot affect parties' substantial rights. A judicial innovation is not an unbridled horse to be allowed to roam about freely in any direction it likes at its pleasure. This is laid down in a ruling of the Madhya Pradesh High Court reported in AIR 1988, Madhya Pradesh, page 50, notes of cases. The next point. As per the CPC, where the party is a minor or insane, the court appoints a guardian ad litem or a court guardian. The court will not conduct the case on behalf of the disabled person. In the adversarial system, advocates who are also officers of the court take care of the benefits of the inquisitorial process by resorting to discovery and inspection under Order 11 Civil Procedure Code and Order 12 Civil Procedure Code. In his fascinating book, Why Lawsuits Are Good for America, Professor Carl T. Bogus writes, open quote, trial lawyers do not have to rely on whatever documents manufacturers turn over a response to written requests. Here manufacturers means manufacturers of automobiles. They may summon company employees to testify under oath. This discovery device often shines a light into the otherwise impenetrable darkness of the corporate interior. So, what I would like to say is, it is the advocates who are also unofficial judges, but they are inquisitorial judges. Inquisitorial unofficial judges. Because they discover the truth. Their first discovery starts with lawyer's notice. When a client approaches, we are not supposed to file a case straight away. On the basis of the client's instructions, we are supposed to issue a lawyer's notice to the opposite side. Under instructions from my client so and so, I address you as under the facts of the case. Come on, you are called upon to do this or not to do this. Failing which, legal action will be taken against you. Then the opposite side goes to the lawyer, another lawyer. He is also an inquisitorial unofficial judge. He also applies the law to the facts of the case as narrated to him by his client and comes to a conclusion whether the contents of the notice issued by me are tenable or not tenable. If he feels that they are tenable, he should advise his client, Baba, no point in litigation. You better compromise the matter. If you go to court, you will be the loser. Justice Oliver Wendell Holmes, he had observed nearly a century ago that what is law? Law is a prophecy of what courts would decide. That means it's a prediction of what court would decide. If you know the law, you can predict how the judgment would be. Let me take a simple example. A person is accused of driving on the wrong side of the road. The lawyer knows the law that one should drive only on the left in India. In America, it's the reverse. So the lawyer finds out from the video that his client was driving only on the left side. So he will tell the client, don't worry, in spite of the prosecution, you are bound to succeed. That prosecution is going to fail. That means the judge is going to acquit you. So that is the prediction he makes. Let's take another case. Suppose the same client is actually driving the car on the right side and there is an accident. The lawyer will say, no. Obviously, by applying the law, you have done the wrong thing. This is not America, this is India. So, as per the law of the land, you are guilty and the judge is going to find you guilty. So, better you admit the offense and pay the fine. And in more serious cases, you can resort to plea bargain. In America, 98% of the criminal cases are decided by plea bargain. What it means is, the prosecutor, who is also a lawyer, acts as an unofficial judge before launching the prosecution and decides whether the evidence that the police are going to place is sufficient to convict the accused or not. Then, once the accused goes to the defense lawyer, he also says the same thing. Yes, Baba, as per your instructions and as per the law of the land, you seem to be guilty. No point in contesting the cases. Better you go in for a plea bargain. That's how the cases are decided quickly. Lot of strain on the judges is removed. 98%, mind you. 98% of the cases are decided like this in America. There also, some lawyers challenge the procedure of plea bargain in the Supreme Court there, saying it affects the fundamental right of the accused to contest a case and all that. But the Supreme Court there said nothing doing. If the traditional method of contest in every case is allowed, our justice system is simply going to collapse. Our means their American justice system. We must know in America, the government allots much more funds to the judiciary than our government is prepared to do. In spite of all that, the legal system there came forward with the procedure of plea bargain. Way back in 1970s, the Supreme Court there upheld that procedure. Now we are nearly 50 years behind them. And though the plea bargain was introduced nearly a decade ago in our CRPC, nobody is bothered. So this is how, and everybody talks about delay, and these Lok Adalats. What is happening in the Lok Adalats? The police are virtually forcing the complainants to compromise. Judges are requesting the police. How absurd it is. Next point. The court must decide the issue raised by the parties and not impose its views. This is laid down in a ruling reported in AIR Supreme Court Weekly 2000, page 794. Court must decide only those points that are raised by the parties. If new points are to be decided, both the parties must be notified as a principle of natural justice. This is laid down in a judgment of the Supreme Court reported in 2003 AIR Supreme Court Weekly, page 4504. Next point. Even the Supreme Court cannot deviate from the law on moral considerations